Can you hear me? I just want to check.
Yes, I hear you.
Yes, Judge.
I'm just waiting on Judge Alley. Liz, do you want to go down the hall and just check to see if he needs something?
Yes, I will.
Thank you.
Sorry, we had some button I didn't press.
No problem. I've just, we're live on YouTube and we're recording. And I just want to be sure everybody's ready. Liz, you're not out of breath. We're all ready.
Yes, I'm good.
So let me let the attorneys in.
Okay.
All right. It's Ms. Choser, is that correct?
It's Choker, Your Honor.
Choker, thank you. I appreciate that. And Ms. Owen, I'm assuming she's connected.
Miss Owen, if we can ask you to please turn on your video.
Yes, ma'am. Hold on a second, please. Bear with me. Is that better?
Yes. Okay. That's fine.
Okay.
All right, Ms. Flores, do you want to announce court?
Yes. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And the court calls the case of 08-20-00152 CV, Commissioner of Education Mike Morath in his official capacity in the Texas Education Agency versus the Texas American Federation of Teachers and Texas State Teachers Association. And I think the Attorney General is going to proceed first.
Madam Chief Justice, and may it please the court. Your Honors, this case is not about striking a balance between the interests of teachers on the one hand and the interests of their students on the other, nor is it the court's job to weigh the relative merits of different educational policies. The sole question before the court today is, what policies did the legislature adopt based on the plain text of the Education Code? And the three answers to that inquiry are as follows. Number one, whether or not it seems fair, the legislature guaranteed local teachers greater input into their school district's contracts with certain types of operating partners and not others. Number two, although the legislature created a presumption in favor of local policy, the legislature did not require school districts to separately opt out of individual policies by name and number. And finally, whatever the benefits of subjecting the commissioner's approval or denial of eligibility to judicial review, the legislature never created that right of appeal. For these reasons, we ask that the court reverse the trial court's judgment and render judgment in favor of defendants. First, the consultation rule is valid because the legislature chose to guarantee teachers a seat at the table for contracts with A1 operating partners, but not for contracts with A2 operating partners. Notably, the only court of appeals to consider this question to date reached the same result as the TEA, that A2 operating partners fall outside the scope of subsection C of section 11174. And there are two separate principles of statutory construction that mandate the exclusion of A2 operating partners from the phrase open enrollment charter school. First, the broader definition impermissibly renders subsection A1 entirely superfluous. And number two, that definition also creates an irreconcilable conflict between subsections L and M. Starting with superfluousness, the one material difference between subsection A1 and A2 is that partnerships with A2 operating partners are eligible for exemptions and funding only on approval by the commissioner. Thus, maintaining the two categories is crucial because only one of the two requires approval by the commissioner. However, as the state mentioned in our brief, both A1 and A2 operating partners are required to fall under one of the four categories of eligible entities listed in subchapter D. As a result, the only way to distinguish which eligible entities require approval from the commissioner is by interpreting the phrase open enrollment charter school to exclude entities that never obtained a charter from the commissioner under subchapter D. As for the irreconcilable conflict that Appellee's definition creates, subsection M explicitly grants the commissioner authority to adopt standards for A2 operating partners to receive approval. However, subsection L denies the commissioner authority to impose requirements for an open enrollment charter school to be eligible for a contract. Under Appellee's definition, there's simply no way for the commissioner to permissibly adopt a requirement for an A2 operating partner without impermissibly adopting a requirement for an open enrollment charter school.
Counsel, if I could interrupt you, I mean, we appreciate the statutory construction, but we always kind of like to know the why behind some of these things. And so you have Chapter C charters that seem to have relatively less regulation or restrictions than you have on Chapter D charters. And so if the legislature has kind of made this distinction where they say, I guess, an already approved open enrollment charter that falls under 11.174 is treated differently than, I guess, an A2 entity. What was the rationale behind that? What's the policy reason that drove them?
Well, unfortunately, the legislature didn't specify the motivating rationale behind subsection C or between the distinction between A1 and A2. However, under principles of statutory interpretation, we ask, are there plausible, non-absurd reasons for that distinction? And I don't want to speculate about exactly why the legislature did what it did, but there are some plausible reasons, such as the fact that historically, open enrollment charter schools have been considered competitors as to local school districts, and therefore have been viewed as a little bit more controversial among local teachers. And so the legislature may have felt that adding additional protections for contracts in that context might allay some concerns. Alternatively, the legislature may have trusted the additional regulations over subchapter D charters such that it didn't want to require additional approval by the commissioner. However, the legislature, given the automatic nature of those partnerships, the legislature may have wanted to allow teachers an opportunity to have input into that process. For example, open enrollment charters are not created in response to a particular district's needs. They're pre-existing entities with pre-existing operating procedures and structures, and it may be harder to adapt an entity that's already in existence like that to local circumstances than it is to adapt an entity that purely exists and is bound by the needs of the district granting the charter.
So, and just to be clear, if a local school district chose an A2 operating partner, there's nothing in the statute that would preclude them from incorporating a consultation rule or protecting existing contract rights. It's just that they're not required to. Is that correct?
Yes, Your Honor, that is correct. And furthermore, the fact that a contractual provision is required for approval of eligibility doesn't necessarily alter the applicability of subsection C on its own, for example. So if you take a case like Martinez and assume that had been a situation with an A1 operating partner such that there wasn't an issue, then so another piece of this is that under section 11.174, if the commissioner doesn't notify the district of its decision within 60 days, the contract is considered approved. So if you take a scenario like that, where a contract didn't include the provision, there would still be a question about the requirements of subsection C. So again, local school districts can choose to provide additional protection for subchapter C charter school teachers, as Your Honor noted, and then conversely, whether or not that provision is included in the performance contract is not determinative of the freestanding obligation that teachers' rights should not be negatively impacted by the performance contract. Unless Your Honors have further questions on the consultation rule, I'd like to shift gears to talking about the local policy rule. The local policy rule is not invalid because section 12054 does not prohibit school districts from drafting their exemptions so broad as to effectively, but not technically, abandon the default rule that Section 12054 creates in favor of local policy. There's just no requirement that performance contracts itemize or enumerate inapplicable policies. Those words do not appear in Section 12054. And as the examples the state provided in our brief show, the words specifically exempted are often used in other contract contexts simply to mean explicitly, as it does here. Under that interpretation, what Section 12054 is really doing is essentially creating a default rule of contract interpretation that there are no exemptions by implication. So suppose a performance contract term conflicts with local policy. Under ordinary principles of contract law, the court would look to the contract's language to determine whether the drafter's intent was to create an implied exception. Instead, under the Section 12054 presumption, there are no exemptions by implication. Any exemption must be explicitly, i.e. specifically, provided for. And the way this sort of works in practice, setting aside the local policy rule for a second, but just to illustrate how the operation of explicit exemptions that are broader than individual policies works. For example, a school district could exempt a charter school from local policies passed prior to 2000. That's still specific enough that one can discern which policies are applicable or not, but it is still a broader category than just listing out each policy. Similarly, the school district could do it by subject matter and exempt a charter from local policies pertaining to required curriculums. By the same token, those categories would still work if the school district exempted the charter school from any pre-2000 policy except grading policy. It just doesn't change whether the exemption is specific or not. So once you accept that some level of generalization or categorization of policies is permissible under Section 12054, there's just no basis for determining when does a category of exemption become too broad to be considered specific under Section 12054. And that's all the local policy rule is really doing. It requires the broadest possible opt-out subject to certain exceptions. And again, just turning to the example from earlier about if the commissioner doesn't notify the school district within 60 days, the performance contract is considered approved and eligible for benefits. Under that circumstance, if a contract was approved essentially by operation of law that did not include the required provision under the local policy rule, that school district would still be eligible for benefits because it was approved by operation of law. But if a dispute arose down the road as to whether a particular local policy was applicable to a teacher or a student, that no one's going to be able to argue in that matter, well, they were supposed to have included a provision that said it under which it would be inapplicable except for listed exceptions. That's not what would happen. It's Section 12054 would apply per usual, just as it does in scenarios where the district enters into a subchapter C partnership but doesn't also seek eligibility of benefits. Unless the court has any other questions, finally, I'd like to discuss the final decision rule, which is valid because it doesn't narrow the availability of appeal because there is no appeal to narrow. We agree with appellees that once the legislature has provided for judicial review, the commissioner has no power to change when that review is available. But the insurmountable hurdle for appellees here is showing that the legislature created that right of appeal in the first place.
why doesn't section 7 point, I'm sorry, I have lost the number, the 7.057, why doesn't that, I mean, that seems to pretty clearly say that somebody who's upset with their with the decision of the commissioner has a right to file a suit in Austin.
Your Honor, admittedly, a literal reading of subsection D would authorize judicial review of any action or decision of the commissioner or the TEA. That is the literal reading, but binding precedent from the Austin Court of Appeals has rejected that reading of section 7057D. So, for example, in TEA versus American Youth Works, there was a provision in Chapter 12 that expressly prohibits judicial review, but in discussing its holding, the Austin Court of Appeals also said not only does the Education Code not provide for judicial review of the commissioner's revocation decision, and there are other decisions in context other than the Education Code that reiterate that even when the literal reading does suggest that that broad of a right of review is being created, that those clauses have to be interpreted in the context of the well-established background, which disfavors waivers of sovereign immunity and the notion that administrative actions generally aren't reviewable, that there's just a presumption against waivers of sovereign immunity that applies here. And it's important to note that appellant's reading would expand judicial review to an unprecedented number of the commissioner's decisions, well beyond the scope of subsection A. So in context, when you read section 7057 as a whole, it becomes more clear that subsection D is really just referring to what happens after someone appeals to the board of the school board of trustees, and after that gets appealed to the commissioner.
So, Counselor, if that's true, though, why did the legislature in a whole bunch of other contexts, like revocation decisions for charters, have specific provisions that say the decision of the commissioner is not appealable? In other words, I think I found 4 or 5 situations where within the Education Code, the legislature has specifically decided this decision is not appealable. And if they don't have that provision here, isn't that some suggestion that they believe that decision would be appealable?
No, Your Honor. There are 4 or 5 examples of what you're talking about, but there are examples going the other way as well. So, for example, section 49013 of the Education Code, which deals with the commissioner's determination of wealth equalization, that provision specifically, I think it's subsection A, specifically says, except for subchapter D, a decision of the commissioner under this chapter is appealable under section 7057. So, if the circumstances were that, there really was an overwhelming ratio of decisions of statutes where the legislature clarified that appeal wasn't available versus instances where the legislature clarified that appeal was available, that might be something that the court could take into consideration in resolving the ambiguousness, but the examples just aren't that clear cut. And
so Counselor, here's my hypothetical. Let's say a local school district goes under A2 and chooses as its partner, let's say, a for-profit entity, which would not qualify under 11.174. And let's say for whatever reason, Commissioner Morath or his successor was asleep at the wheel and approved it, or maybe they just missed the 60-day deadline and it was approved. Are you suggesting that there would be no appeal from that decision approving an entity that is clearly not permitted under the statute to be a partner?
Your Honor, there would be no appeal under Section 7057 directly to Travis County District Court. That doesn't mean that that there isn't a suit that concerned parties or aggrieved parties could bring to challenge that lack of compliance with the statute. Again, looking to Martinez as an example, that lawsuit was brought by a group of teachers against the school board and the board of trustees and individual members of the trustees. The commissioner was not a party. It was an ultra vires suit seeking declaratory and injunctive relief that the school district had impermissibly entered into that contract with the operating partner, contrary to the requirements of Section 11174. And what that case really illustrates, setting aside the fact that it didn't involve an open enrollment charter school, what it illustrates is that in every scenario where somebody wants to complain that a proposed operating partnership contract, Your Honor, I assume your time has expired. If I may finish my answer. In every scenario involving one of these contracts, the school board is going to be a party to that contract, and therefore there's going to be most likely an opportunity for someone to complain either ultra vires or under subsection A of Section 7057. Thank you.
Thank you. Ms. Owen?
May it please the court, counsel. I'll address each of the rules in turn, but just generally the framework for the teacher's position is that when it enacted 11.174, the legislature built upon a series of already existing provisions in subchapter C and D in chapter 12 of the Education Code. The parties agree that all of the entities eligible for a contract, both the A1 and the A2 entities, must be granted a school district charter to operate a campus under subchapter C. Just because the commissioner and the State Board of Education, for example, have approved a particular charter operator like the KIPS or the IDEA Public Charter Schools of the world to open and run a charter school doesn't mean it's authorized to take over a school district campus in a particular district. And so in order to do that, the district has to grant the entity a charter under subchapter C. And the parties agreed that the legislature intended that the commissioner would develop additional criteria that he would use for approving contracts with A2 entities that A1 entities would not be subject to, but that contracts for all types of entities must still be approved. So turning kind of with that backdrop and turning to the consultation rule and the commissioner's carve out for A2 entities. In our brief, we discussed several arguments, but I'm going to focus on 3 of them today, as well as the Fourth Circuit's decision in the Martinez case. First, the commissioner's rule ignores the district charter authorization provision in subchapter C of chapter 12. In making its argument that the consultation provision is limited to A1 entities granted a charter under subchapter D and doesn't extend to the A2 entities granted a charter under subchapter C, the commissioner doesn't adequately account for the impact of 11.174D, which says that to operate a charter provided by the section, the district campus must be granted a charter under subchapter C. This is a critical provision because it brings all the provisions governing subchapter C into the picture, including section 12.0522D, the district charter authorization provision. That section states explicitly that subchapter D applies to a campus granted a district charter as though the campus had been granted a charter under subchapter D, and the campus is considered an open enrollment charter school. Again, this isn't some random section of the education code that doesn't have a bearing on 11.174. This is a pre-existing provision regarding charter schools that the legislature explicitly imported into 11.174, and that the legislature is presumed to have known what it was referencing. And so what this provision provides in essence is that anytime a district issues a charter to a campus under subchapter C, it creates an open enrollment charter school. And we know from 11.174D that the school district has to issue a campus charter to all entities, A1 or A2. But once that subchapter C charter is granted to the eligible entity to operate a campus, as contemplated and required by the statute, the distinction falls away, and the term open enrollment charter refers to all campuses, whichever or regardless of which type of entity is operating them. So my point is they may have different starting points, these charters granted to A1s and A2s, one with the commissioner and SBOE, and the other with the local school district, but they are all deemed open enrollment charter school.
Counselor, though, if you could kind of address the opposing argument that if that's true, then every charter under 11.174 winds up being an open enrollment charter. And so why even have 11.174 A1 and 2, and then within the following provisions? In B, for instance, in A and B, it makes distinctions on disqualifications for open enrollment, and then C makes a disqualification for a district selected charter, and you could go all the way through M and find where the legislature's used open enrollment or it's used A2. In other words, it seems to draw a distinction throughout the statute, yet you say there really isn't.
Your Honor, what we see that the subsection A is, as the way it operates, is that in that subsection A, the distinction between A1s and A2 makes sense in that context of that subsection, because it sets out the two entities, the two types of entities who could qualify. But Your Honor, we don't believe that that distinction is carried out through the rest of the statute. In fact, subsection A1 is never mentioned again in all of 11.174, and except for a couple of mentions of A2, the rest of the provisions in 11.174 are to subsection A, which is general and we think encompasses both, or to section 11.174 generally. So we think that, again, the distinction is specific to that context of subsection A describing the charters, and with the legislature highlighting these are the kinds of people or these are the kinds of entities that could qualify. But once they get the charter, which they have to do once the district issues them the charter, and that's a requirement, A1 and 2, the district has to issue that charter, then the statute says they become open enrollment charter schools. And specifically and I know Your Honor mentioned a couple of sections, but let me kind of hone in on subsection C, because that's the consultation provision that the teachers are so interested in. And it's not just consultation, it's also contract protection. I have to say that. But it says, it refers to the section. It doesn't, why wouldn't it say, if the legislature had intended it to be limited, why wouldn't it say under section A1? So we think that the broader references in the statute as a whole indicate that the open enrollment charter school, once it gets that charter, it operates under, with the broader categories in mind.
Setting aside 11.174 and just focusing on 12.0522, is there any authority, either case law or rule-based, that would say that a charter that is set up under 12.0522 by virtue of subsection D is then subject to all the different regulatory provisions under for a subchapter D open enrollment school charter? I mean, when I looked at subchapter D, I think I found like 18 separate provisions that for restrictions on open enrollment charters for which there's no counterpart in chapter C. And so clearly there seems to be a whole lot more regulation of open enrollment charters than district chartered. So the question is, if you truly went under 12.0522, is there any authority that says that then loops in all the regulatory provisions for chapter D?
I'm not aware of any cases, Your Honor, but we do think that that's what the statute says when it says that the campus is considered an open enrollment charter school, as if the charter were granted a charter under subchapter D.
Is there anything in the commissioner's regulations that suggest that they are actively regulating charter or district charter entities under 12.0522?
I think that if I understand the court's question, yes, I think that the commissioner has rules regarding, obviously it has rules regarding the classic subchapter D scenario. And then in subchapter C, I think that the rules that would come into play are the rules that are at issue in this case.
Ms. Owen, can I ask you, if the argument, well, if the distinction is maintained, which is going against what you're arguing, but if that distinction is maintained, what is the adverse impact on the teachers?
If the distinction is maintained and teachers aren't entitled to have consultation rights with these A2 charters, well, I think it's a matter of local record or public record that the vast majority of entities that have applied to operate applied to get the benefits under Senate Bill 1882, which 11.174 enacts, that the vast majority of them are the nonprofits and mostly nonprofits, and that those are the ones who are applying for these benefits. So that means that you have and I can't quote you the numbers exactly, but you have a huge swath of entities that are coming in and getting applying for these benefits, but are not complying with the statutory regulations. And it also, sets up this kind of untenable situation that I think the court alluded to earlier, perhaps, and that is that you've got the idea behind the statute is that we want to give these benefits to this group of entities, and yet we're applying such different rules to those entities that are, and especially with regard to these teacher protection provisions, cut them out and don't have them apply at all.
But just to follow up on that, I mean, let's say you have a local school district and it's got a school that's failing because these provisions only apply to schools that have failed their students. And so they choose an A2 entity as opposed to an A1 entity. They still have the ability to consult with the teachers who are their employees and the ability to protect their rights if they so choose. Correct?
Well, no, I wouldn't agree with that. And the reason is that is the other provision we were discussing, the local policy provision, and the way that the commissioner has come in and told school districts that they've got to exempt these entities from local school policies, unless the unless the district goes in and specifically enumerates them. So yes, I suppose that if the local school district specifically enumerated that policy in its performance contract, perhaps those would apply. However, I think that when that application was shipped off to the commissioner for approval, that it may very well be rejected because it's not that complete exemption from local policies that the commissioner has insisted upon in 1075D6.
Well, on the local policy rule, if we can kind of move there, this
Sure.
seems more of a procedural issue to me that would really affect the scriveners of these contracts. I mean, either the performance contract says none of the local policies and procedures apply except for A, B, C, D, E, F, and G, or whatever they list, or it says the following local provisions do not apply, A, B, C, D, E, F, and G, and everything else does. And so it seemed to me almost a matter of convenience, because since the commissioner has to review these contracts, it's a whole lot easier to look at one unified document that tells me everything that's going to apply, rather than for the commissioner to have to guess what policies, the Muleshoe School District has versus the Lubbock School District has buried somewhere in their archives that they may not know about. Well,
I mean, I think that, one response is that's what the statute requires, and that the commissioner's not free by rule to deviate from the statute. And I guess that the concern is to address your point, and I think it's a fair point that it's a sort of just a matter of how they get there. But the reality is, if you're an employee of a school district and there are certain local policies that you have that you believe are protective of your rights or interest in some manner, that yes, there's a great deal of concern that those policies are not going to be, they're not going to take the trouble to go through the policies and then write out which ones apply. And we think that, and we do think that that's what is called for. And if it's a lot of trouble, well then, that's, it is some trouble. But if you're going to count, not cover people by exempting the coverage of the policies, then that's what, I think that what's required is that there be some sort of reasoned decision making to exempt them with the default, what the statute, and that's what the statute calls for. The default is that they apply. So I can't see the clock, and I'm not sure if I have any time. But I did want to mention.
You do have 2.5 minutes left.
Okay. All right. Let me just, if I could move to the final decision rule. And, we have two objections to this rule. One is that it exceeds the grant of rulemaking authority granted to the commissioner, because there's nothing in the statute restricting judicial appeals at all. And what the principle is that the rule may not impose additional burdens, constraints, or restrictions beyond or inconsistent with statutory provisions. And by saying that there's not going to be any appeal, that's exactly what's done. And I do want to call the court's attention to a case that came out after we filed our brief, and I'll submit a letter with the precise site, but it is on point, and it's TEA versus Houston ISD. It's a Court of Appeals decision, 2020 Westlaw 7757365. I'll provide that again in a letter. But what that case involves is the commissioner's attempted takeover of Houston ISD and the commissioner's resistance to having his actions subject to judicial review. And so what the commissioner did in part was to cite to this administrative rule to support that. But the Austin Court of Appeals rejected that argument and said, look, this is provisions, an agency rule, it's not a statute. And it cited the same language that we cite in our brief to the Sterling City case, the Supreme Court's decision. But in the TEA case, what the court said is, although the legislature has authority to limit judicial review of agency actions, we cannot conclude that an administrative agency has that same authority over the judiciary. And so we think that that's pretty conclusive and succinct statement of what the rule is on limiting judicial appeals by the rule. And specifically with regard to section 7.057, this particular section is one that, as Ms. Choker stated correctly, 7.057 does have that's a provision. D is the provision for judicial appeal. But to get to D, you have to have a case that falls within the categories in subsection A. That is correct. But we can easily envision a situation where we would have, for example, a contract violation under 7.057. Say, for example, the teacher's contract said—
Your time is up, Ms. Owen. Just if you don't mind wrapping it up.
Okay. I'll just finish with that we do think that D is limiting. Thank you. And we request that the court declare the challenged rules invalid under the Administrative Procedure Act.
Thank you. Thank you. Ms. Choker?
May it please the court. Your Honors, I just have a couple of points that I want to make on the consultation rule and the final decision rule. So first, I'd like to address the impact of section 11174D and section 120522D that opposing counsel was addressing. So first of all, in appellee's brief, they say the legislature made clear that all roads to section 11174 lead through subchapter C. But even if that's the case, not all of those roads lead through section 120522. That's just one of multiple ways of creating a subchapter C charter. For example, as we noted in our brief, there are petition-based charters where if someone collects a majority of signatures from parents and teachers in the school district, that's another way that a subchapter C charter gets created. And there's no provision in that section that similarly says, and therefore these types of charters are an open enrollment school as well. The only response appellees had to that in their briefs was to say, oh, but then the parents and teachers are the charter holders. But the reason that rebuttal doesn't work is because there's similar problematic language in the very provision that they're relying on in section 11174D, which says to operate a district campus is provided by this section, the district campus must be granted a charter under subchapter C, chapter 12. So again, appellees just never addressed what about the other types of subchapter C charters. Second, Justice Alley asked a question about whether all of subchapter D then applies. And I think it was, you mentioned 18 regulations in subchapter D that didn't have a corresponding analog in subchapter C. But the problem is actually worse than that, because there are several direct conflicts between the requirements or regulations for subchapter C and the requirements or regulations for subchapter D. They just can't be a subchapter C charter and a subchapter D charter in every way. So just to name a few examples, expiration. Subchapter C makes clear that subchapter C charters expire in 10 years. However, subchapter D charters, meaning the ones granted their charter by the commissioner, those have an initial term of 5 years, and they are eligible for they can request renewal for up to 10 years, but there's just no way to determine, is it the 10-year expiration that applies or the 5-year expiration? Similarly, revision of charters. Under subchapter C, revision of a district charter requires the Board of Trustees approval. However, subchapter D says the commissioner is the only one who can approve a revision to an open enrollment schools charter. Another example would be revocation. So under subchapter C, it's the Board of Trustees that adopts the procedures for determining revocation. And it's the Board of Trustees who is the decision maker as to whether the charter should be revoked. Under subchapter D, it's the commissioner who's responsible for adopting the procedures, and it's the commissioner who's the decision maker. There's just no way to reconcile those differences. And lastly, just funding. Open enrollment schools are funded directly by the state under section 12061A. The district doesn't touch that money. It doesn't go through the district in any way. Subchapter C charter school funding comes from the school district. So whatever monies the district takes in from the state and local property taxes, those are then allocated among the district's campuses. And that's probably the most likely explanation for what work requiring a subchapter D open enrollment charter school to get authorization from the school district separate from the performance contract is doing. It's just clarifying where the funding goes. The other thing I want to note here is that the appellee's tautology, which is an operating partner has to have a subchapter C charter, therefore it is a subchapter D charter, and because it's a subchapter D, it's a subchapter C. It just gets even worse when you really dig into the categories of eligible entities under subchapter D. So for example, the fourth category of entity is I think it's a government entity is how it's framed. And the problem there is open enrollment schools are considered local government entities. I don't have the section number on hand, but there's a provision in subchapter D that clarifies that for purposes of various different chapters that they are a local government entity. And one of those qualities that they obtain is governmental immunity, for example. They are a governmental entity. They would qualify under category 4. But then if any time a district grants a subchapter C charter, which it can do on its own, that entity then becomes an open enrollment school, which then means it's also an eligible entity under section or subsection 4 of that definition. Then there's just absolutely no limit to who the district could then turn into an eligible entity just by virtue of granting a charter under subchapter C. Turning back to the final decision rule, that the TEA versus Houston ISD case that Ms. Owen mentioned just wasn't interpreting section 7057, and it's just not on point. What that case says is While we agree that the legislature generally has the power to limit judicial review of executive actions, making those actions final, citing Morath, in this case, the commissioner has acknowledged that the commissioner's decision is not yet final and the district sued to prevent a final decision. That just doesn't answer the question that the court is faced with here. And similarly, the cases that appellees rely on in their response brief are also in a posit. In Morath versus Sterling ISD, there was an express legislative statement that an administrative determination is final on the availability of justice of judicial review, but Morath never held that the commissioner's decisions are not final unless there is such a provision, and that would be the opposite of the general rule of that administrative decisions aren't reviewable. If they're reviewable unless the legislature specifies that they are final and appealable, then there's just no room left for that unfavored treatment of waivers of sovereign immunity. And then in both Solis and Davis versus Morath, there was no dispute that the teacher's grievance otherwise met the criteria of section 7057A. They were challenging decisions of the school board, not the commissioner. So again, the state agrees that if appeal is available under subsection 7057A, then the commissioner can't limit that review. But that's a separate question from if review isn't available under subsection A, is there another route via subsection D? And just the last point I want to make is to address the suggestion that appellees made in their brief at pages 32 to 33, that the final decision rule somehow cuts off the ability to appeal from matters that start out as being submitted to the commissioner under section 7057A. That's simply not the case. The final decision rule will never cut off an appeal that starts that way. The decision that would be reviewed in the district court action following subsection A would not be the approval or denial of the charter school's eligibility for benefits under section 11174. That's the only decision that the final decision rule says is outside the scope of 7057. Just one quick example, say there's a difference between a 3-year contract term and a 1-year contract term that a teacher could appeal under section 7057A, and she would be able to seek the retention of her position under the old rule of the 3-year contract term, or to be compensated for the additional 2 years. But she's not going to have a justiciable interest in whether the charter school will or will not receive additional funding or exemption from intervention. That's just not going to be at stake in that appeal.
If I could ask one question, Chief. The only final decision rule that they're challenging, and correct me if I'm wrong, is under your rule 97.1079. And that provision says it only deals with the approval or denial of eligibility of an entity to be a A2 partner. Is that correct? In other words, there's not a challenge to the finality rule under 97.1075.
Yes, Your Honor, I believe so.
Okay, all right, thank you.
All right. Thank you very much, counselors, for your excellent argument this morning on a really fine point we have never seen before, and we appreciate you explaining that to us. Your case will be submitted on the briefs and on the excellent argument this morning, and thank you again.
Thank you.